Dear students, the topic which I am going to discuss now is background for adopting the International Covenant on Civil and Political Rights. To begin with, the contemporary history of the development of human rights goes back to the UN Charter, which emphasized on promoting and encouraging respect for human rights and fundamental freedoms for all without distinction as to race, sex, language or religion. The first result of these efforts was the Universal Declaration of Human Rights, that is UDHR, adopted in 1948 by the General Assembly, which covers simultaneously a large range of economic, social and cultural rights as well as traditional, civil and political rights. This document served as a springboard for the two principal international human rights treaties that were opened for signatures in 1966 and went into force in 1976. The International Covenant on Economic, Social and Cultural Rights and the International Covenant on Civil and Political Rights. The Civil and Political Rights Covenant includes and elaborates most upon the parallel rights enumerated in the Universal Declaration. While it does not include the right to own property or the right to asylum, it does include additional rights such as the right to self-determination and certain cultural rights for ethnic, religious and linguistic minorities. The Covenant establishes a Human Rights Committee of 18 elected experts who study reports of the individual states' efforts to guarantee the rights included in the Covenant. The ICCPR has its roots in the same process that led to the Universal Declaration of Human Rights. A declaration on the essential rights of man had been proposed at the 1945 San Francisco Conference, which led to the founding of the United Nations, and the Economic and Social Council, popularly known as ECOSOC, was given the task of drafting it. At the early stage, the document was split into a declaration setting forth general principles of human rights and a convention or covenant containing binding commitments. The former evolved into the UDHR and was adopted on December 10, 1948. Drafting continued on the convention, but there remained significant differences between UN members on the relative importance on negative civil political rights versus positive economic, social and cultural rights. These eventually caused the convention to be split into two separate conventions or covenants, one to contain civil and political rights and the other to contain economic, social and cultural rights. The two covenants were to contain as many similar provisions as possible and to be opened for signatures simultaneously. Each would also contain an article on the right of all peoples to self-determination. The first document became the International Covenant on Economic, Social and Cultural Rights, popularly known as ICCPR, and the second, the International Covenant on Civil and Political Rights, popularly known as ICCPR. The drafts were presented to the UN General Assembly for discussions in 1954 and adopted in 1966. As a result of diplomatic negotiations, the International Covenant on Economic, Social and Cultural Rights was adopted shortly before the International Covenant on Civil and Political Rights. After the horrors of World War II, a broad consensus emerged at the worldwide level demanding that the individual human being be placed under the protection of the international community. As particularly, the atrocities committed against specific ethnic groups had shown national governments could gravely fail in their duty to ensure the life and liberty of their citizens. Since the protective mechanisms at the domestic level alone did not provide sufficiently stable safeguards, it became almost self-evident to entrust the planned New World Organization with assuming the role of guarantor of human rights on an universal scale. At the San Francisco Conference in 1945, some Latin American countries requested that a full code of human rights be included in the Charter of the United Nations itself. Since such an initiative required careful preparation, their motions could not be successful at that stage. Nonetheless, human rights were embraced as a matter of principle. The Charter contains references to human rights in the preamble. Among the purposes of the organization, that is there in Article 1, and in several other provisions like Article 13, 55, 62 and 68. Immediately after the actual setting up of the institutional machinery provided for by the Charter, the new Commission on Human Rights began its work for the creation of an International Bill of Rights. In the first step, the Universal Declaration of Human Rights was drafted, which the General Assembly adopted on 10 December 1948. In order to make human rights an instrument effectively shaping the lives of individuals and nations, more than just a political proclamation was needed. Hence, from the very outset, there was general agreement to the effect that the substance of the Universal Declaration should be translated into the hard legal form of an international treaty. The General Assembly reaffirmed the necessity of complementing, as had already been done in the Universal Declaration, traditional civil and political rights with economic, social and cultural rights, since both classes of rights were interconnected and interdependent. The only question was whether, following the concept of unity of all human rights, the new conventional rights should be encompassed in one international instrument, or whether, on account of their different specificities, they should be arranged according to those specificities. Western nations in particular claimed that the implementation process could not be identical. Economic and social rights partaking more of the nature of goals to be attained, whereas civil and political rights had to be respected strictly and without any reservations. It is this latter view that eventually prevailed. By Resolution 543, Clause 6 of 4th February 1952, the General Assembly directed the Commission on Human Rights to prepare, instead of just one covenant, 2 draft treaties. A covenant setting forth civil and political rights, and a parallel covenant providing for economic, social and cultural rights. The Commission completed its work in 1954, yet it took many years before eventually the political climate was ripe for the adoption of these 2 ambitious texts. Accordingly, on 16 December 1966, the two covenants were adopted by the General Assembly by consensus, without any abstentions. That is the Resolution 2200, Clause 21. Since that time, the two comprehensive human rights instruments of the United Nations have sailed on different courses. However, contrary to many pessimistic expectations, they have mostly been ratified simultaneously. Part 1 of ICCPR starts with the right of self-determination, which is considered to be the foundational stone of all human rights. That is there in the Article 1. Part 2, that is from Article 2 to 5, contains a number of general principles that apply across the board. Among them, in particular, the prohibition on discrimination. Part 3 enunciates an extended list of rights, the first of which being the right to life, that is Article 6. Article 7 establishes a ban on torture or other cruel, inhuman or degrading treatment or punishment, and Article 8 declares slavery and forced or compulsory labor unlawful. Well-balanced guarantees of habeas corpus are set forth in Article 9, and Article 10 provides that all persons deprived of their liberty shall be treated with humanity. Freedom of movement, including the freedom to leave any country, has found its regulation in Article 12 of the Covenant. Aliens who do not enjoy a stable right of sojourn must, as a minimum, be granted due process in case their expulsion is envisaged. It is there in Article 13. Fair trial, the scope of which is confined to criminal prosecution and to civil suits at law, has its seat in Article 14 and 15. Privacy, the family, the home, or the correspondence of a person are placed under the protection of Article 17, and the social activities of human beings enjoy the safeguards of Article 18. There, freedom of thought, conscience and religion is included. Article 19, that is the freedom of expression. Article 21, that is freedom of assembly, and Article 22, which is dealing with the freedom of association. Going beyond the classic dimension of protection against interference by state authorities, Article 23 and 24 proclaims that the family and the child are entitled to protection by society and the state. Article 25 establishes the right for everyone to take part in the running of the public affairs of his or her country. With this provision, the ICCPR makes clear that state authorities require some sort of democratic legitimacy. Finally, Article 27 recognizes an individual right of members of ethnic, religious or linguistic minorities to engage in the cultural activities characteristics of such minorities. No political rights are provided for minorities as such have not been endowed with any rights of political autonomy. Article 26 establishes a clause on equality and non-discrimination which seemingly stands in contrast to Article 2, paragraph 3, the introductory non-discrimination clause, which is ancillary in nature, being applicable only in conjunction with one of the other substantive rights. The Human Rights Committee, the organ entrusted with monitoring compliance by states with their obligations under the ICCPR, has interpreted Article 26 as setting forth a general ban on discrimination without any regard for the field of life concerned. The doctrine of human rights aspires to provide a common framework for determining the basic civil, economic, political and social conditions required for all individuals to lead a minimum good life or minimally good life. At universal plan, the Universal Declaration of Human Rights, that is UDHR 1948, the International Covenant on Civil and Political Rights, that is ICCPR, and the International Covenant on Economic, Social and Cultural Rights, that is ICESCR, were adopted. It is at the national level that the ICCPR has exerted its greatest impact. When anywhere in the world a national constitution is framed, the ICCPR serves as the natural yardstick for the drafting and inserting provisions of fundamental rights. In most countries, the ICCPR has been made part and parcel of the national legal order, although there is no general rule of international law that would enjoin states to embrace a specific method of implementation. In some countries, administrative authorities and the courts are specifically enjoined to follow the applicable international guarantees when interpreting the national constitution. Even some countries, the ICCPR has been given the legal force of a provision of constitutional or quasi-constitutional rank.